pass out a sign-in sheet. So I just need you to print your name here. It says print. And sign your name there. And hopefully next week I'll get around to printing up a nice fancy one, but this will do for tonight. We didn't do a sign-in sheet last week for those of you that weren't here because I had bad drops, so I didn't do sign-in. If you were here last week, just see me after class. I'll kind of bring you up to speed a little bit. Okay. And then does everybody have a syllabus now? Everybody's got it. Okay. Good. Yeah. Very cool. Let me just pass that around. Okay. So just to kind of bring you back up to speed from last week. Last week we talked about, starting on page 3, a little bit about the different categories and classifications of law. And we're just going to keep going on with that theme tonight. We're going to talk about more so page 4, which we'll get to in a minute, about the various sources of law that we have. But just remember for the midterm, this is one of those pages that's likely to be a fill in the blank question. And basically it'd be list 4 different categories of law. And I want you to know primarily the difference between civil and criminal laws. And that is whether or not there's potential jail time as a penalty. So now let's get over to page 4. Because page 4 is really, we're going to spend most of the evening on page 4. So as you can see here at the top, first of all, to begin with, 100%. This for sure will be on the midterm as a fill in the blank question. Guaranteed, I ask it every single term, same question over and over again. What are 6 sources of law? It might be only 4, but memorize up to 6. And then you just fill in the blank, anything off of this page. So with that said, let me just kind of give you some background. So there's a lot going on this page. I mean, when you first read through it, you kind of go, okay, that's just a list of various different laws that we have. And that's true. That's part of it. But there's more going on in the background. So first of all, I've divided it up into federal and state laws. And we'll get into that detail in a minute. But the other thing that's going on here is it's telling you the names of the different types of laws we have. But it's also setting up a list of authority level of various different laws. And so in that respect, it's kind of like, I'm going to make a comparison to the game of poker. Like when you play poker, right? You have various different levels of hands. And so if we're playing poker, for example, assuming there's no wild cards, the best hand you can have would be a royal flush. And so if I have a royal flush, I'm going to beat you if you only have 4 of a kind. Right? Thank you. And so, oh, you didn't get it? Pull back row. Okay. So what I mean by that is, like in poker, we have various different levels of law. And so a higher law will override or beat, like in poker, a lower level law. And we're going to get into that here more in detail in just a moment. But that's part of what I want you guys to know on this page, is which laws are of higher level and which laws are of lower level. And like I said, we're going to go through that in detail. The green stripes that I have here, these are the sources of law that I want you to be able to put into correct order. And we'll get into that more in a minute. So that's the other thing that's going on. It's a list of laws, yes, but it's also giving us a list of the laws more or less in order of authority, as we'll see in a moment. So last week we talked about this beginning idea, and that's what we're going to pick up today, of a federal system. And what does that mean? And how does that apply when we talk about levels of law? So just to remind you, we are a federal system of law in the United States, meaning that we have 50 states, which are of, in essence, lower level, and we have one federal government, which is the United States federal government for the United States of America. So we, as a federal system, the idea being that each of the states have given power to the federal government that they would otherwise have as a sovereign state. The power to make money, for example. The power to engage in international relations. The power to have an army or a navy, military power. That's all transferred to the federal government. So to begin with, we're going to start with the idea of our poker game. And that is the idea that federal law is of higher authority, thank you, than state law. Okay? I have federal law, and then I have the various different federal laws listed here. And then down below we have state law. So that's going to bring up our first major fundamental concept of United States law that I want you to know about. And we're going to turn over a couple pages here to page 8. Federal supremacy and the doctrine of preemption. It's a very important page. I have a number of test questions that come off of this page. So just in a nutshell, we're talking about why federal law is of a higher level authority than state law. And here's where we find this information in the Constitution. So to begin with, let's go down here. This is Article 6 of the United States Constitution. Okay? We're on page 8. Paragraph 2, where we say Clause 2. This Constitution and the law of the United States which shall be made in pursuance thereof, and all treaties, which shall be made under the authority of the United States, and I have this all caps and bold, I added that, shall be the supreme law of the land, and the judges of every state shall be bound thereby. Does anybody know what this paragraph is called? The something clause, not the Santa Claus. Supremacy clause. Thank you. Exactly. Right here. The supremacy clause. So this is the part of the U.S. Constitution that sets up this fundamental idea that federal law is a higher level than state law. And what does that mean? That means that if a state law is written that conflicts with the federal law will beat the state law. The state law is invalid. It's either, if it violates the Constitution, it would be unconstitutional, or if it violates some other lower level federal law, that federal law would override the state law. So this is what we call the doctrine of preemption. Very important concept in the United States legal system, not just federal versus state, but we see it at all levels of government. State, city, county, federal, state, all throughout the system. So, first of all, what does this word preemption mean? What does that word, just in everyday language, mean? Well, basically it means of a higher level, to come before, to override. That's the word I like. That's why I have it highlighted right here. So the doctrine of preemption is this idea that something will come before or override something else. Now in law, we look at this as having a higher level law that will override a lower level law. And when that's the case, the higher level law will preempt or override the lower law, and the lower law will lose. Poker, back to the game of poker with cards, is a game of preemption, right? That's the whole point of the game. I'm trying to get a better hand in poker than you have, so I can beat you. In law, we kind of do the same thing. We as lawyers look for the highest level law that we can find to base our legal argument on that's relevant. And if we have a better, higher law than the other side, we win, hopefully, right? With the U.S. Constitution being at the top. And we'll get more to that in a minute. So first of all, a couple things on this page I want you to know. This term here, or this paragraph, the supremacy clause. That is the part of the U.S. Constitution that sets up the idea that federal law is a higher level law and will therefore override a state law, a city law, a county law, or any other lower level law. That comes from the supremacy clause. The doctrine of preemption is the idea that higher laws will override lower laws. Not just federal or state, but all levels, right? So within a state system, a higher level state law will override a lower level law, maybe a state law versus a city law, and on down the line. So the doctrine of preemption is the idea of levels of law. It is, right here, the doctrine of preemption is based upon the supremacy clause. That has been a test question of mine in the past. What part of the Constitution creates the doctrine of preemption? Answer, supremacy clause. Which part of the Constitution sets up this idea? Supremacy clause. Okay? So the doctrine of preemption, first of all, I want you to know what that means. And that is, higher law will override lower law. Real simple. Now there's a little bit more to it than that in the real world, but for you guys at this level, that's all I want you to know. Higher law will beat lower law. It comes directly out of the idea that federal law is higher than state law, which is part of the supremacy clause. All right, pretty straightforward. And again, we also see this same idea at state versus city and county levels, which we'll talk more about in a minute. So all throughout our legal system. All right, so let's go back to page 4 and start working our way through these various laws, starting with the U.S. Constitution. Now, before we go further, you're probably wondering what in the world this little thing I wrote in over here. You know what that is? Obviously, I'm not an art major, right? What does that look like? Any guesses? A funnel. Very good. What does that have to do with law? All right. Now, again, page 4, sources of law. There's a lot going on in the background on this page. And one of them is what I call the funnel effect of law. We kind of see the same thing in the court system, which we'll get into next week. So here's the idea of why I put a funnel there. At the top of the funnel, we have a big opening. It's not very precise. It's not very directed. It applies to a large area. As you work your way down the funnel, it gets more and more precise, directed, focused, whatever you want to call it. That's the whole point of a funnel. Well, law is kind of the same way. The higher the level of law we have, like a funnel, the larger the area that it applies to. So, for example, the United States Constitution applies throughout the United States, right? Very large area. In fact, in some instances, it actually can apply internationally. But like a funnel, the higher the level of the law, the less defined, or the less specific, or another way of saying, the less detail is found in that higher law. And so if you want detail, you've got to start going down the list to look for more specific laws, like we have in a funnel. And so basically what's happening is as we work our way down this list, the laws are becoming more and more and more defined and specific, more targeted. They're also going to apply to a smaller group of people. And I'll show you what I mean in a little bit in detail. So I call that the funnel effect. Now just kind of keep that in mind as we're working our way through these various different laws. All right, so let's start with the royal flush of law. That is the United States Constitution. So first things first, I have it at number 1, which means under the doctrine of preemption and federal supremacy, it will override every other law that we have. If there's a lower law that conflicts with it, the U.S. Constitution wins and beats that law. Right? We would call it unconstitutional in everyday language. So, next thing I want you to know is this word constitution. What does it mean? Now when I say constitution, you probably think of the United States Constitution. That's fine. But we use the word constitution just in a more general sense. We see it not just at the federal level, but every state has a form of a constitution. We also see it outside of government in the private sector. Corporations have a form of a constitution. We call it by different names. So in a corporation, we would call it bylaws. Nonprofits have a constitutional document that may be called a charter or a membership agreement, or it may be called bylaws or some other type of similar document. We see it in unions, in governmental entities like cities. They call it a city charter. There are various different terms that basically mean the same thing. So I've written up here the 2 basic purposes of a constitutional document. What are the two functional basic purposes of a constitution? That is, what does a constitution do? And this is both at governmental level and in the private sector, right? So number one, a constitution is a document that organizes how government is set up, right? It sets up the organizational structure of a government. And I'll show you what I mean in just a minute in detail. The second purpose of the Constitution is to define and reserve rights, in the case of the federal Constitution, of the people and of the states. That's the 10th Amendment. Any powers not delegated to the federal government are reserved to the states and the people. So those are the two purposes. That's a test question. I'll tell you right now. I ask it in various different ways, but basically the question is, what are the two purposes of a Constitution? Answer: organize government and reserve rights. Reserve rights. Okay? So let's flip over to page, I think it's 6. Yes, page 6. Okay. Okay, so this is an overview of the U.S. Constitution. Constitution of the United States. I just want to show you something. So I'm going to blow this up here. So we have right here Article 1, 2, and 3. Roman numeral 1, Roman numeral 2, and number 3. The legislative department, the executive department, and the judicial department. So the U.S. Constitution creates 3 different branches of government, 3 of them. The legislative branch, the executive branch, and the judicial branch. That is the organizational function I was just talking about. When they wrote the Constitution, they came up with 3 branches of government. We'll get into that more in just a minute. Now down below here, we have the amendments to the Constitution. The first 10 I've highlighted, of course. Those are known as the Bill of Rights. Most of you guys know that already. And I apologize for my really bad handwriting here. And by the way, I have a lot of students. If you guys want to take pictures of my notes, that's fine. I don't care. I know some people care, but I don't. So feel free if you want to snap a picture with your phone or whatever. Go ahead. So the Bill of Rights. Now, that's primarily where we see the part of the Constitution that defines and reserves rights. It's not just the first 10 amendments, however. The reservation of rights function of the Constitution is throughout. I mean, we see it throughout the whole of the Constitution. 14th Amendment, of course, equal protection, all that kind of stuff. So, again, the 2 basic purposes: organize government, define and reserve rights. Those are the 2 basic purposes. So let's talk more in depth now about the organizational part. So page 7. All right, so this is my cut and paste job of the U.S. Constitution. Literally, I pulled my copy of the Constitution out and photocopied it and cut and pasted it. Literally, old school. So here we have Article 1, Article 2, and Article 3. I just want to show you this. So Article 1. All legislative power herein granted shall be vested in a Congress which shall consist of the Senate and the House of Representatives. So that's the first branch of government, the first department created by the Constitution. The legislative branch, the power to legislate. So what is that power? Like in just simple plain English. The power to do what with law? Any ideas? To do what? What does legislate mean?
Force.
What was it?
Force.
Force? Enforce? Force, you're on the right track, but different branch.
Implement.
Implement, I like that word. That's a great word. Implement. Another word.
Apply.
Apply. What does the legislature do? Well, that's a good question. But no, what do they do? What's their basic function? To do what with the law?
Bills.
Build. What's another? You're on the right track. I'm looking for a very specific word. What am I doing? does this do? Right, thank you. To make law, to write the law, to create the law. So yeah, you're on the right track over there, absolutely. So we're talking about the three basic functions, and now it's kind of political science-y. The three basic functions of a government is to create law first, and then have that law enforced, and then have that law carried out, right? So the legislative function at its very basic core is to make law. Now let me explain what I mean by it. Legislate means more than just make law or write law. Okay, it's more than just that. I mean, I could sit down right now with this piece of paper and I could write a law. I hereby impose a 100% income tax on everybody payable to the John Hasbrook wants to go to Italy this summer fund. Oh, I like that law. Right? I'm going to go to Lake Como. In Milan. See my friend. So, I just wrote a law. I'm a lawyer, I can do that, right? But I don't have the power to legislate. It's more than just the ability to write a law. What do I mean by that? I don't have what power? If I don't have legislative power, I'm lacking what ability to do what with that thing, that law I just wrote? What power don't I have? And I could go hand it out to all you guys, and you're going to laugh at me. Why? Because I don't have legislative power. So what do I mean by that, theoretically speaking? The power to do what with that written document?
No,
What is it?
no. Power,
I have really bad hearing, so sorry.
power to make law.
Yeah, the power to make law. In other words, the power to make you follow it, right? You're exactly on point. So the idea is, I don't have the power to impose it upon the public. I can write the law all I want, but I don't have the legal power to put it out there and make the public follow it. That is the power to legislate. It's not just to write the law, but it's the power given to a government to put it on the public. Remember last week we talked about public and private law? That's what I'm talking about when I say public law. Legislated law. That is law that's created by the appropriate government body and then imposed upon the public. So legislative power is the power to make law. That is to write it and have it imposed on the public. It's a basic function of government. One of the basic functions of government throughout the world, right? It doesn't matter where you're talking. All right, I already gave it away. My next one, Article 2. The executive power shall be vested in a President of the United States of America. All right, so the executive power, the second basic function of a government. So in one word, what is the job of the executive to do what with the law? I wrote it up there. Enforce, okay? So the legislature writes the law, and then it's up to the executive branch to enforce the law. That's the second basic function of a government. Now here it says that that power is vested in the president, all right? So, okay, that's fine, but real world time. How is the law actually enforced in the real world? I mean, the president's not driving around in a cop car, kicking doors down and serving search warrants and reading people Miranda rights and stuff, right? That's not how it happens. How is it done in the real world?
Police.
The police, that's one way, absolutely. How else? Who else enforces law? Not just the police.
Army.
Army, yeah, military. What about tax time? Who enforces tax law? I've been doing taxes all day, so it's on my mind, right? Payroll taxes are due by the 1099s and W-2s. So who enforces tax law? IRS, right? Internal Revenue Service. So here's where I'm going, okay? The executive power is held by the president, at a state level by the governor, at a city level by the mayor, at a county level by a county commissioner. So the executive power is the power to enforce the law. Now the way that that's done is, of course, through the chief executive, in this case the president, but it's delegated. It's transferred to police, military, and agencies, bureaus, commissions. We call these administrative agencies. Now, for purposes of this class, I'm going to talk about administrative law quite a bit. It's becoming a very important area of law. It's been growing over the last several decades. I mean, exploding, really. Administrative law. And so, for purposes of this class, when I talk about administrative law, those administrative agencies fall under the executive department. Now, what am I talking about? I'm talking about like the FAA, Federal Aviation Administration, the SEC, Securities Exchange Commission, the Department of Treasury, the Department of Labor, the Department of Transportation, all of the I call them the alphabet agencies, the Environmental Protection Agency, EPA, all of those agencies, right? The IRS, the FBI, all of them fall under, of our three branches of government here, the executive branch. Now I say, with that with a little asterisk, there are some agencies that fall under legislative, like DAS, and then under the judicial, but you guys don't need to worry about that, okay? For this class, the agencies that I'm talking about and I'm going to be referring to fall under the overall part of the executive, right, in terms of our three branches of government. Now, it's going to become important later on. I want you to keep that in the back of your mind when we talk about agencies. Same thing at a state level here in Oregon. We have a whole number of different agencies, so like the Department of Environmental Quality, DEQ, the Construction Contractors Board that regulate contractors, the Oregon Board of Dentistry regulates dentists, the Oregon Department of Fish and Wildlife, ODFW, Department of Transportation, ODOT, all the different agencies we have, right? So they're tasked with carrying out and enforcing the law. So that's under Article 2, power at the state level in our Oregon Constitution. All right, the third branch of government, the judicial branch, Article 3. The judicial power of the United States shall be vested in a Supreme Court and such inferior courts as Congress may from time to time ordain and establish, all right? Real simple. The basic purpose or function of the judicial branch is to do what with the law? And that says interpret. Bad handwriting, I know. To interpret the law. And I'll show you exactly how that works here in a few minutes. But just for right now, when we say interpret, what I mean by that basically is a judge will decide, in conjunction with a jury if it's a jury trial, during a court hearing, did the person who's accused violate the law? And then if so, what punishment or fine, criminal or civil, needs to be imposed. So decide, did the person actually violate the law? And if so, what is the outcome that will be applied? So in general, okay, first of all, real basic, I want you to know, number one, what are the three branches of the United States government? LEJ. Legislative, executive, judicial. Right? That's a test question. It's basic. It's easy. You guys should all get that one right. What are the three branches of government under the U.S. Constitution? What are they called? Legislative, executive, judicial. So we have three. I want you to know the basic function of each. Legislative, make or write law. Executive, enforce the law. Judicial, interpret, apply, carry out, whatever you want to call it, the law, right? Now, with that said, I got my water here. That leads us to this idea of why, when they wrote the Constitution, why have three branches of government? Could they have had five? Yeah, they could have. Why? Yeah.
Separation of power.
Ah, very good. Separation of powers. That's what we're leading up to, is that term, separation of powers. But let's step back a minute. Why separate the powers? To avoid what? Historically speaking, what were they trying to avoid when they wrote the Constitution, at least in the United States?
Probably a little too dramatic, but tyranny.
Tyranny, what's another word? And I'm talking historically now. Go back to the Revolutionary War, English monarchy, right? Okay, to avoid a monarchy. Now, what do we mean by that? Okay, monarchy, mono, one person in charge. So now we're talking again political science. The idea of a monarchy is one person has legislative power. I hereby enact 100% tax. Executive power, you're not paying me 100% tax. Judicial power, I hereby carry out sentence. I'm going to seize all your property, put you in jail. One person had all three powers, right? So in other words, all the power of government was held, in the case of a king or a queen, a monarchy, one person. Or it could be a group of people, like a triumvirate, a group of three, or a cabal, you know, a group of five or whatever. The point being, separation of powers is so that not one person or one group, small group of people has all the power of government, to separate them out, to divide them up. Now again, they set it up in 3 branches. Theoretically, you could have more than that. Other countries are organized where they actually have like 5 branches, where they have combinations of legislative and judicial, executive and judicial, executive and legislative. We in reality kind of have 4 branches when you add all the administrative agencies that some of them kind of operate on their own. But on paper, we have 3 branches. Now, separation of powers, that's what we're leading up to. Page 11. Three fundamental concepts of United States law that start with the letter S. I made this up. It's my own thing. But this will help you remember. 3 primary, fundamental, foundational ideas of the United States legal system, right? We've already talked about the first one, that is supremacy. Supremacy is the idea, first of all, federal law will override state law, and it also sets up the idea of preemption. Higher law will override lower law, okay? The second one is separation of powers. So this is the idea that through the Constitution, the powers, the major powers of a government are divided to avoid one person or a small group of people having all of that power. This also leads to the idea of checks and balances. Now, most of you guys know this already. So checks and balances. Checks and balances. So let's just talk about that real quick. We're going to get into it a little bit more later on in the term. But for right now, what is a check and what is a balance? Just in like plain language. Any ideas? What's a check? Just in, you know, theoretically speaking or conceptually. What is it in hockey? If I check somebody, what am I doing? Throwing them up against the wall, right? In other words, I'm stopping what they're doing. I'm checking what they're doing. Law. A check is basically a limitation on power or the ability to stop what a government is doing, an action of government. So one idea of a check is one branch of government being able to stop what another branch is doing. A check on the power of another branch of government. Another idea of a check is a limitation of power, like the rights that we have, which are a limitation on governmental power. First Amendment free expression, for example. That's a limit on power. It's called an independent check. So a check is a limitation on power, or the ability of one branch to stop what another branch is doing. A check on that power. What's a balance? Any idea? What are some words that we would describe a balance? Sharing, right? Sharing of power. So a balance is when it requires 2 branches of government to work together to get something done. A cooperation of power. So for example, one type of a check is veto power. The president has veto power, can say no to a proposed new law or an amendment to a law. A bill that's sent to them to the president by Congress, the president, if they don't agree, can say no. Veto power is no. Veto. It's a check on the legislative power. A balance. If the president agrees with the proposed law, the president signs it, it becomes law. That's a sharing of power. In the European Union, they have the same thing. They call it, it's kind of a cool term, the co-decision-making process. That's what they term that in the European Union. So they have the same idea, right? What are some other checks? You know, well, I'll show you. Page 44. Getting a little ahead of myself, but that's okay. We got to get through all this stuff at some point. So page 44, possible fill-in-the-blank question. List some types of checks and balances, okay? Pretty basic, most of you guys know this already. So veto power is a check. When the president says no to a law, this is E, sorry, it's kind of blurry. That's the executive checking the legislative, E versus L, right? If the president vetoes a law, Congress can still pass that law, but they have to override the veto with a 2/3 majority vote, which is pretty hard to do, right? A supermajority. So if that were to occur, that would be a check from the legislative branch against the executive. So it would be a check against the president. So like the first check, and then this would be the second check, or a discount double check. No? That's a bad check. Okay. Impeachment, right? Impeachment is the ability of the legislative branch to remove a member of the executive branch, the president, cabinet members, a member of the judicial branch, like a judge. In fact, we had a federal judge here impeached about 4 years ago, I think it was, for taking bribes, basically. It's not clear if the legislative can impeach their own. There was actually one that I'm aware of, oh gosh, many 100-something years ago, but probably not. But basically remove a member of the executive or the judicial from office. Impeachment, removal from office, is that a check or a balance? What would you say? Yeah, that's pretty much a check, right? We'll get to treaties back here in a minute, in just a few minutes, but treaties must be approved by the Senate, and so just keep that in the back of your mind. The president can enter into a treaty, but the Senate has to approve it, and I'll talk more about that in a few minutes. And we'll get into these other ones later on. So just for tonight, real basic. What is a check? A limit on power. A stop. You know, one branch stops another one. A balance, a sharing of power. All right. Back to page 4. So, separation of powers, 3 branches of government. That's what I want you to know tonight. Basic idea of checks and balances. Separating these powers out so one branch doesn't get all the power. Now, on separation of powers, there's another component I want you to understand. Part of this idea of separation of powers is that each branch has their basic function: make law, enforce law, interpret the law, or apply the law. If one branch is acting outside the scope of that power, they don't have the legal authority to do that. And therefore it violates the concept of separation of powers, and what they're doing is illegal. So for example, if a judge, member of the judicial branch, was out driving around in a patrol car, arresting people, and then bringing them before themselves in court, that's the judge engaging in executive power. That is the power to investigate law, make allegations of a violation of law, a prosecutorial function, and that would violate separation of powers, because the judge basically is now investigating and enforcing and making the decision. So that would violate separation of powers. Now, we don't really see that happen. Or the legislature, same way. If they write a law, and then they're also now the ones that are enforcing the law, that would violate separation of powers. Or the executive branch. You have a member of the executive branch rewriting or making new law or engaging in applying, interpreting and applying punishment. That would violate separation of powers. Now, that doesn't happen all that often, but it does occasionally happen. And if that's the case, then that's an unconstitutional action. I've actually had to argue that before a few times, mostly involving administrative rules that were written beyond the scope of the power. And we'll talk more about that a little later. All right. Organize, reserve rights. The two basic purposes of a constitution. Let's talk about that word reserve for a minute. I wrote that word on purpose, reserve, as opposed to give rights. What's the difference? Reserve or give? Why did I not say give rights? Yeah.
I think reserve rights, do you mean make sure people don't lose their rights?
Don't lose their rights. In other words, let me ask it a different way. Does the Constitution give you the right to free speech?
You already have.
You already have it. Exactly. You're born with it. That's the one of our fundamental concepts as well. Fundamental rights, they're called. The law, it's called natural law, which we don't go into all the historical idea. But basically the idea is you are born with these rights. Therefore, the Constitution defines, reserves, protects those rights. Not give them to you. You already have them, right? It's a fundamental nuance, I know, but it's very important. You already have those rights, okay? And so the idea behind the Constitution is, this is called due process. If your rights are going to be taken away, life, liberty, or property, then you have a right to a hearing or a trial or some other way to contest that. That's fundamental. Now, I know I'm all over the place tonight. Don't worry about it. We're going to be talking about these ideas over and over. I will tell you what I want you to focus on. For right now, two things. Organize, reserve rights. If you know that much, you're good. Legislative, executive, judicial. If you know that much, you're good. Their basic functions: make law, enforce law, interpret law. If you know that much, you're good. Supremacy, higher versus lower law. Higher law will override. If you know just those basics. Right? All the detail I'm going into, don't worry about it, okay? All right. Let's keep going on down the list. So, at the federal level, highest law is the U.S. Constitution. Now let's go down for a minute at the state level. Each state will have its own constitutional type of document. Again, same purpose. Organize, reserve rights. So the Oregon State Constitution organizes how the state of Oregon is set up. So like the federal government, we have legislative branch in Oregon. So we have the State House of Representatives and the State of Oregon Senate over in Salem. They make state law. We have the executive branch, which is, what is the president equivalent in the state called? We have a president of Oregon? No, we have what? Highest level in Oregon government is called what? Come on, you guys know this. Who's in charge of Oregon? Not me. Who? What do we call that office? I'll give you a hint. They're in Salem. It starts with the letter G. The governor. Thank you. The governor, right? That's the equivalent of the president. And then, of course, we have the court system throughout the state of Oregon. We have state of Oregon courts with the Oregon Supreme Court, Court of Appeals, and then lower level courts. And we'll talk about courts next week, all right? Now, I just want to show you something real quick. This is kind of interesting. This is that funnel thing I'm talking about. So, you don't need to turn your page. You just look up here. So this is an overview of Article 1 of the Oregon Constitution. So this is Oregon's version of the Bill of Rights under the State of Oregon Constitution. Now remember, in the federal Constitution, there's the first 10 amendments, or the federal Bill of Rights. In Oregon, we divide it up by sections, and you'll notice here, we have 45 sections under the Oregon Bill of Rights. 10 amendments federal, 45 in Oregon. So what's going on there? Well, under Oregon Bill of Rights, it's expanded. So I'll just show you something. If you look at the top here, the different rights under Oregon, looks real similar to what you see in the federal Constitution. Freedom of worship, freedom of religious opinion, no religious test for witnesses or jurors, freedom of speech in the press, unreasonable search and seizures are prohibited, no double jeopardy. Same basic rights you see in the federal Constitution reserved. But now we have it in Oregon. Let me just show you something kind of cool here. Section 8, Article 1, Section 8 of Oregon's Constitution. This is our state of Oregon First Amendment right, okay? Freedom of speech and press. No law shall be passed restraining the free expression of opinion or restricting the right to speak, write, or print freely on any subject whatever. But every person shall be responsible for abuse of this right, whatever that means, right? What just happened here? This is the funnel. It's getting more specific, right? Think about it for a minute. The U.S. Constitution, freedom of speech, First Amendment. Congress shall make no law abridging the freedom of speech. That's what it says. What's that, 6 words or something? Here in Oregon, speak, write, or print. The U.S. Constitution doesn't say write or print. It only says speak. So what just happened? Isn't that a conflict? Remember that whole supremacy thing? What do you think? Is that a conflict? Does this conflict with the First Amendment of the U.S. Constitution?
It's kind of more specific.
Exactly. And what else is happening? Is it conflicting or is it expanding?
No, expanded.
Expanding, exactly. So no, this doesn't conflict. This is saying you in Oregon have more rights on paper than the federal Constitution would say you have. Now I will tell you in the real world, the term speech in the U.S. Constitution has been interpreted not just verbal communication, but also nonverbal communication. So the courts have expanded that definition already. But this is just an example of what I'm talking about, right? We work our way down the funnel, the laws become more specific, more defined, and I'm going to show you even more than that as we work our way through. By the way, in Oregon, Article 1, Section 8, we have very, very open free speech laws in Oregon. I mean, our Oregon Supreme Court is really open when it comes to our speech. Oh, all right. Now, for you guys, okay, I just want to tell you something so you don't waste your time. When I give you a page like this, you're like, oh my goodness, do I have to memorize all those sections? And oh, wow, no. I'm showing you this just so you see what the law really looks like in the real world. You don't need to memorize. In fact, after tonight, you can just kind of forget this page. I just show you this because I want you to see what examples, right? So don't worry about that unless I tell you very specifically and clearly that I want you to know the number or the section or something of a law, and I will be very specific. It's pretty rare that I want you to know that. Don't worry about memorizing all of you, okay? This is purely for your understanding, so you see what the law really looks like. I will tell you very clearly, over and over again, if I want you to know the number to a specific law, like Article 2 of the Uniform Commercial Code, which we'll talk about after the mention. Other than that, don't worry about the numbers. Don't worry about which amendment tells about what rights. I don't test on any of that kind of stuff, right? This is more generalized knowledge. All right, let's keep on moving here. So back to our page 4. So the next source of law, L, right here. And L down there. Do you know what that's for? Yeah, which branch creates that law? Okay, so legislative branch creates the constitutional law. Legislative branch. All right, so the next source of law is a treaty. Number 2 on my list. So what's a treaty? Anybody know? How would you define the term treaty? That's something you give out at Halloween? A trick or treaty? No? Yeah.
Agreement between two or more of the parties?
What kind of parties? You're exactly correct. Agreement between...
Conflict parties?
Agreement between the part, not people, but
Agencies?
not, well, sort of, countries, right, international, okay? So a trick-or treaty. An international agreement. So a treaty is an agreement between countries or more than one country. So a bilateral treaty or a multilateral treaty, or it could be, like what you were saying, agencies like the United Nations, which we call that an IGO, Intergovernmental Organization, or the World Trade Organization, the WTO. The European Union is a large IGO. So all I want you to know is simple. A treaty is an international agreement, okay? Simple. The President, under the U.S. Constitution, has the authority to negotiate and enter into treaties. That power is given to the executive branch. Now back to checks and balances, what we talked about a few minutes ago. If the President enters into a treaty, it must be approved by the Senate. We call that ratification. So it's got to be approved by the Senate upon the advice and consent of the Senate. All right? Now, I want to show you something. I have treaties at number 2 on my list, which means they're right below the royal flush in terms of our poker game. Very high level law. Where does that come from? And you don't need to turn your page, I'll just show it to you. Back to that supremacy clause thing, right there. There's the word treaty in the supremacy clause, saying it's part of the highest law of the land. Back to page 4. Again, I apologize for jumping around. So I have it number 2 on my list. Now, in reality, it might be 2 or 3, but in my mind, it's number 2. I'll tell you what. In the real world, a treaty actually can have the ability to override every other lower law. So I'll give you one example. WTO. You know what that stands for? World Trade Organization, right? What does the World Trade Organization do? It's an international organization, kind of like the United Nations of international business law. It is headquartered in Geneva, Switzerland, and there are about 160, more or less, countries that are members of the World Trade Organization. And basically their job is to, there are treaties involving all 160 countries on tariffs, transactions that are international, services that cross borders, basically having the countries have the same laws involving things like business law. But the other part that the WTO does is what we call intellectual property. Patent law, trademark, copyright, service marks, brands, music, digital, movies, all that kind of thing. So where am I going, all right? So when the WTO came into existence in 1995, at that time, United States law, which was a statute, provided 17 years of protection for a patent. Patent is protection for an invention. The treaty with the WTO requires 20 years of protection. So all countries that are part of the WTO have to have a 20-year protection law. U.S. law was 17 years. The treaty said 20. We have a conflict now. So what do we have to do? We actually had to do this. We had to change our law from 17 years to 20 years because our lower law was in conflict with the treaty. So in essence, what happened there is the treaty required a change of law. So in other words, it overrode this lower level law. Now that's not real common. You're not going to see that all the time. But it does happen. It's happening more and more often as we have more international global organizations like the WTO, like the United Nations, like the European Union, things like that. So that is also why, I want you to think about this for a minute, it's required that the Senate approve a treaty. You're like, oh, why don't you just let the President go enter into treaties? Well, think about that for a moment. If the president can enter into a treaty, and that treaty can override an act of Congress, that in essence is what kind of power? Not legislative, but what? I mean, not executive, but legislative, right? So a treaty, actually, if you think about it, the president has the ability to legislate through making treaties. Now, this was recognized when the Constitution was written, and that's why it's required that the Senate has to approve a treaty. Because otherwise, the president could basically override acts of Congress through treaty making. There's a big debate about that, always has been for hundreds of years, on how far a treaty can go. Beyond the scope of this class, right? All I want you to know, treaty, number one, international agreement. Number two, president enters into a treaty. Number three, it has to be approved by the Senate, okay? If you know that much, you're good. All right, let's move on to number three, statutory law. All right, so this word statutory, statutes, plural, singular, statute, not statue like that's art, like David, but a statute with a T right there. Statutory law. Statute. I'm going to say it over and over again because I want you to know what that word means. Here's the definition. A statute or statutory law is the body of law written by a legislature. Statutory law is legislated law. It's law that's created by the legislature. Legislatures write statutes. I can say it 4 or 5 different ways. That's a test question. What do we call, who makes statutes? Legislative branch. That's your answer, okay? Yeah.
Why do they think?
Say that again, sorry.
What is the purpose?
Oh, okay. So statutory law, when Congress writes law at the federal level or at the state level, these are the rules that basically are these are the laws that are your everyday law. Like the laws that deal with your everyday life, right? The Constitution, not very specific. Treaties, international. So that doesn't really deal with your everyday, day-to-day things. Statutory law, that's your everyday stuff. So like speed limits, right? 65 miles per hour on the highway. That's a statute. Or how old do you have to be to get a driver's license? That's going to be in the form of a statute. So in some ways, statutory law is the most important source of law for like everyday life, everyday living. And most of the, if you ever have a question, the first place you should look is go look up the statute to find out what it says. Because that's where you're going to find like your everyday answers to things. So at the federal level, we have what's called the United States Code, abbreviated USC. That's what we call federal law, right? US Code. That's what law that Congress passes. Now states also have statutes. So all the legislatures of every state will write their own statutes. In Oregon, and I have this highlighted on purpose because I want you to know this term, we have the Oregon Revised Statutes. We abbreviate that as ORS. ORS. And I have that highlighted because I have a test question. What does ORS mean? Answer, Oregon Revised Statutes. That would be like a true-false question. Here's right out of my law library. I brought this from my law. Oregon Revised Statutes. So these are the laws that are passed by the state of Oregon. Now again, this is your everyday life kind of stuff. This is where you're going to read the rules that govern what you do on a day-to-day basis, both in business, when you're driving around your car, criminal law. This is where we're going to find criminal law are in the statutes. So every state's going to have statutes. They call them by different names. So like in Nevada, they have the NRS, the Nevada Revised Statutes. In California, they call it Code, California Code. But it's still statutory law. It's a law that was written by the California legislature. So they go by different names throughout the U.S. I don't really care about that. All I want you to know is the word statute means legislated law. We have legislative branch at all levels of government, Congress at the federal level, state of Oregon, at the city level. What would be the legislative branch at the city level, you may know? What would we call it? City council, right? Counties, we have the county commission. So they go by different names, but we have legislative law at all branches. At a city level, we call it city code. At a county level, it's like Monmouth City Code, here in Monmouth. County, Polk County Code. And that's going to involve the law within the city limits of Monmouth, Polk County, Benton County, Marion County, wherever it happened to be. All right, so ORS. ORS, Oregon Revised Statutes. So if I ask you this test question, what is the source of the Oregon Revised Statutes? Which branch of government? You got three possible answers. L, E, or J? L, legislative. State legislature, right? Okay. So, let's keep going here. Then I'll show you an example of what they look like. Next, we have administrative rules. Number 4 on our list in federal, and number 3 on our list here at the state level. So, an administrative rule. First of all, what is an administrative rule? An administrative rule, this is what I was talking about earlier with administrative agencies, are rules that are written by various different agencies, commissions, bureaus that we have, and there are dozens and dozens and dozens of them at the federal level, dozens and dozens and dozens at the state level. So, like for example, the FAA, Federal Aviation Administration, the Federal Department of Transportation, Federal Highway Administration, all of those, they write rules. And those are rules that, depending on what area of law they have authority over, you have to follow if you're involved in that law. And they're very, very detailed. I mean, super detailed. At the federal level, we call them the Code of Federal Regulations. There are virtually hundreds of thousands of these rules. The CFRs. CFR. Now I point that out because it's real common, you'll hear this in business all the time, especially in highly regulated industries like aviation, trucking, shipping, railroads, atomic energy, things like that. This is where you have safety regulations that are put out by federal law. And it's real common to hear, okay, what do the CFR say? Or what do the regs say that you have to do? And that's what they're referring to. What do the regulations say? So let me show you what they look like, just real world, okay? So I brought this with me. Remember I told you I used to do a lot of commercial trucking law. I used to work for a trucking company as their lawyer. And I'd carry this book around with me everywhere I went. If you're a truck driver, you carry one of these books with you. These are the safety regulations that you have to follow if you're a commercial truck driver, semi-truck, a bus, etc. So these are put out by the United States Department of Transportation. So these are administrative rules for truck drivers. So I'll just show you what I mean when I say specific. Any tire on the front wheel of a bus, truck, or truck tractor shall have a tread, groove, pattern, depth of at least 4/32 of an inch. That's pretty specific, right? Or, let me show you another one. Like here. Your flatbed, you got coiled steel. This is how you have to load them. You got to put a strap through them. If you don't load it that way, or if you don't have that much tread on your tire, you get pulled over by a police officer, you go through a weigh station, they actually have a little thing that measures your tire, you're going to get a ticket. It's going to be a whole lot of money. If you're a truck driver, you got to keep a logbook. Looks something like this. Nowadays they're all electronic, but back in the day they were paper. And when you're on off duty, when you're sleeping, when you're driving, when you're on duty but not driving, you got to say where you're at, how many hours you were doing it, all that kind of stuff. I mean, there are, you can see here there are page after page after page of these. And if you violate these, you're subject to monetary fine, license suspension, and maybe even criminal. Okay? So that's what I mean by administrative rules. Now at the state level, so I want to show you something here. At the state level, we call them the Oregon Administrative Rules, which I have on your list on page 4 at number 3. They're state law. We abbreviate that OAR. And so this is where, when you're in business, you're going to find business regulations. If you're in education, like the Department of Education rules, especially for special education rules that we have. We have lots of these different administrative agencies. So I just want to show you kind of an example of what I'm talking about. So we have, let me blow that up so you can see a little better. So we have like the Oregon Health Authority, we have the Department of Justice, Department of State Lands, Department of Revenue. Those are all pretty straightforward ones. Let me find some interesting ones here. Here we go, like the Oregon Department of Agriculture, Mint Commission, the Sheep Commission, the Dungeness Crab Commission, Orchard Grass Commission, the Potato Commission, strawberry, sweet cherry, blueberry, wheat, you get water resources, on down the line. There are mortuaries, Oregon Liquor Control Commission, OLCC, regulates bars and serving alcohol. Board of Nursing, real estate, if you're a real estate agent, on down the line. And so they have very, very detailed rules. Oregon Board of Dentistry, that's what my wife has to do with them. So it's like this, my wife's a dentist, so she has to follow, these are rules that talk about patient care, record keeping, and they're very, 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 very detailed. They go on for hundreds and hundreds of pages. And if you violate these rules, well, as a dentist, you can have your license pulled, or you're subject to a monetary fine. For businesses, same type of thing. All right. So just look real quick here, and I'll show you some statutory authority. ORS 679. ORS means what? Oregon Revised Statute. Okay, so keep that in your mind for a minute. Statutory authority. Statutory authority. I'm going to tell you why that's important. Back to page 4. Okay, so we're going to put this all together now for you guys. 4 levels of law at the federal, 3 levels at the state. Highest, of course, is the U.S. Constitution. So the U.S. Constitution will beat every other law on this page in our poker game. Treaty, next highest level. Won't beat the Constitution, but it'll beat the other ones. Federal statutory law will beat all the ones below it. Federal administrative rule. Can't beat a statute of the treaty or U.S. Constitution, but beats all the other ones, because it's federal. State law, state constitution, highest law, state statutes, ORS, and then state administrative rules. All right, now I want you to think about something. L-E-L-E. These are the branches of government. I want you to write that down under notes. Legislative, constitution. Executive, treaty law. Legislative, statutory. Administrative rules, remember what I said earlier? They fall under the executive department. So this is law that's created by which branch of government? The executive. That's what I'm holding right here. Law created by the Department of Transportation, which is part of the executive branch. I'm going to jump, well, before I get there. Okay, so I want you to think about that for a minute, right? Back to separation of powers. So I'm holding safety regulations, and if you're a truck driver, you can have your license suspended forever, lose your whole livelihood, and or pay a huge fine, or both. Which branch of government wrote this law? These laws. They're administrative rules, which means they're written by the executive branch, okay? So they wrote the law. Who enforces this law? Guess what? The same people that wrote it. Who then decides what your fine's going to be? Guess what? The same people that wrote it. Now think about that for a minute. How does that go together with separation of powers? If you have the same branch writing the law that they enforce and also pass judgment on, in a way, because it's done through administrative hearing. Interesting, isn't it?
Isn't it just because they have the authority on that?
Very good.
That's it.
Very good. Okay, that's why I was pointing out to you earlier statutory authority. The reason why, the only reason why that this can be lawful under the Constitution with separation of powers is if there is a statute giving them the authority to make those rules and to enforce them. This is called enabling legislation. But here's the idea. Congress, and at the state level, and ORS, through the legislature, they don't have time nor the knowledge, like in nuclear energy or that kind of thing, to go into the detail in a statute. And so basically what's happening is they're delegating the detail to these agencies. And they then write a statute that will create the agency and then say, we hereby give the agency the authority to write rules to carry out the statutes that we've written. That's why I was showing you that statutory authority. Every administrative rule at the federal level or the state level has to have legislated authority to begin with. Otherwise, it violates separation of powers. That's what I talked about earlier, where I've had to litigate that. We had a rule that violated the statute. Went beyond the authority given to them when they wrote the rule, or directly conflicted with the statute, in which case that rule is invalid, right? It's preempted by the statute. That does sometimes happen, here and there. So long story short, it's a lot more detail. I really want you guys to know. I just want you to be aware that that could be a problem. Higher laws, lower laws, preemption, poker, right? Put these in order. I'll mix them up on the test, and I'll say, put these four in a proper order. Constitution, treaty, statute, administrative rule. State level, Constitution, statute, administrative rule. That's why I have these in green. Those are the ones I want you to know in order. All right. 5 and 6. So I'm going to come back to court decisions in a minute. I want to talk about executive orders real quick. Number 6 at federal. And where do I have number 4 here? At the state level. So I'm not going to spend a lot of time on them, but just real quickly, an executive order is, as the name implies, an order from the chief executive of whatever branch of government or level of government. So at the U.S. level, it would be the President of the United States. At the state level, it would be the governor. In a city, it would be the mayor, and on down the line.